Sometimes, for various reasons, parties to a federal lawsuit will want to amend their pleadings. For example, a defendant may move to dismiss the plaintiff's complaint for failure to state a claim on which relief can be granted. Rather than having the whole case thrown out, the plaintiff may seek to amend the complaint so that it does state a claim upon which relief can be granted. Similarly, the defendant may want to amend her answer to assert additional defenses or to fix ineffective denials in the original answer. The specific rules governing amendments to pleadings are set forth in Federal Rule 15. First, let's discuss when a party may amend her pleading without asking permission of either the court or the opposing side. Once the time for amendments as a matter of course has passed, however, a party will need either permission from the court or the consent of the opposing side to amend a pleading. Therefore, we'll talk about the standard that usually governs the issue of whether the court should grant leave to amend at that stage when the consent of the opposing side is not forthcoming. Lastly, we'll talk very briefly about the concept of relation back, where amendments to pleadings will be treated for procedural purposes as if they had been incorporated into the original pleading on the date that it was filed with the court. Since relation back usually only deals with amendments that add new claims, defenses, or parties to the lawsuit, we'll treat these provisions in more detail in a later tutorial covering claims and joinder of parties. We'll summarize everything briefly, and then we'll have a quiz to illustrate the concepts we discussed and to test your understanding. Now let's talk about amending pleadings as a matter of course. Rule 15a1 provides that a party may amend its pleading once as a matter of course within either A, 21 days after serving it on the opposition, or B, if the pleading sought to be amended is one to which a response is required, then the pleading can be amended once as a matter of course within 21 days after the response is served. In order to figure out which pleadings require a response, we need to look to Federal Rule 7, which sets forth which pleadings are allowed. Rule 7 lists all of the various types of pleadings that are permitted under the federal rule for them. Some types of pleadings have responsive pleadings listed for them, others don't. In determining whether a responsive pleading is required under Rule 15a, the advisory committee notes and the treatises indicate that we look to Rule 7 to ascertain the types of pleadings for which a response is permitted. If a responsive pleading is permitted under Rule 11, then it is considered to be required under Rule 15a. Obviously, a complaint is a pleading for which a response is required. For purposes of Rule 15a1, a responsive pleading can consist of either an answer or a pre-answer motion, even though pre-answer motions aren't technically pleadings. Therefore, a plaintiff can amend his complaint without anyone's permission within 21 days after service of an answer or a pre-answer motion. Only 3 kinds of pre-answer motions will set the countdown clock running on the 21-day period: a motion to dismiss under Rule 12b, a motion for a more definite statement under Rule 12e, or a motion to strike under Rule 12f.